how did the court martial start trying civilians? In my opinion, what happened is this: in the general election of 2001, I think many of you were very young, very young. For us, I was already practicing advocate, so I saw what happened. There was a lot of thuggery. Actually, that election was so bad. There was so much thuggery. People were using guns recklessly in that election. And if you go back and read the findings of the Supreme Court in that election, in the petition, you'll find that all those things were proved. That there was so much thuggery. So now these thugs who were robbing people became a problem to government because they had been given a kind of license. They thought they can go ahead and continue getting wealthy by robbing people. So how do you manage such a crisis? So they decided that the constitutional, that the field marshal, that the court martial shall try civilians. It was really for managing a crisis that the state had created itself. I was in court. I represented many people in 2001 when were the first chairperson was Mr. General Tumuine. General Edith Tumuine was the first chairperson, and he said some of the cases, he dismissed some of the cases and said they were not fit to go to him. I remember I was representing, there's one of the people I was representing had been a building at a certain site, and the owner of the site alleged that a doorbell had gone missing. So this young man was beaten up and tortured and brought to court martial and charged with robbery. So Tumuine dismissed those cases. He transferred them to Uganda Road Court. He said they did not fit to be tried in that court. So the thing is this: that court can be abused because there's no DPP, there's nobody to sieve out the chaff. The court can be abused. And let me tell you people, a person is not supposed to lose his liberty. A person is supposed to have his liberty, in other words, to be free to move. But the Constitution says if you commit an offense and the court has tried, you are in court, you can lose your liberty. So once the legal process is set into motion, the legal process should be set into motion for a person who really, there is a likelihood that that person has committed an offense. Because even the Constitution says there must be a likelihood that a person has committed an offense. That likelihood should not be through conjecture. It should not be through a whim. It should be through real. That the suspicion should be reasonable. Should have been arrived upon through investigations. Now the problem with the court martial, there are no investigations. Okay, the military does its own investigation, we don't know. But then, for me, the cases I've handled in that court, really, like that case of the doorbell. There are so many such cases that have ended. Then, in 2006, 2007, actually, the Supreme Court, in the late judgments of Justice Mulenga, said that a person who has nothing to do with the military should not be tried in military courts. So what the military did, all the people they had arrested, they would say, "You have been found with a weapon, ordinarily the monopoly of the UPDF." They amended the charges and said so and so is being charged with being found in a possession with a weapon, ordinarily in the monopoly of the UPDF. Now the problem with that is there's a problem with that one because you see, under the I heard there was one case of Hadija Namgero. Hadija Namgero was a paternal aunt of Salim Muhammad. Now Hadija Namgero came to me seeking a representation of her son, of her nephew. Salim Muhammad had been found with a star pistol in Makinde there, and charged with being found with a weapon, being a monopoly of the UPDF. Now a star pistol, how can you say it is the UPDF has the monopoly of the star pistol? When you read the Firearms Act, and when you read the Firearms Act makes most of those weapons are licensable, including SMG. All those are licensable weapons. Of course, there are weapons which are not licensable, like for example, a tank. If you have a tank, and that is one is really the monopoly of the defense force, or grenades or that kind of thing. That one should, on the face of it, is ordinarily the monopoly of the UPDF. Go to the court martial and be tried there. But really, it is very unfair to try civilians in court martial, because that court has been abused, and we need to do something about it. And you see, for example, if they say that you have been charged with aiding and abetting the commission of a service offense by a person subject to military law, even that one is a problem, because you see, aiding and abetting is an ingredient of an offense which must be proved through trial. If it is an ingredient of an offense to be proved through trial, for example, at one point, after the prosecution has presented its case, the court must rule whether there's a case to answer or not. How about if the court says that actually it's not true, that there's no evidence that you aided and abetted this crime? That one is a problem. A person shall have already gone through, shall already have lost his liberty and a legal process that is unlawful. So you people, I'm calling upon everybody of you, whether through prayer or whatever that can be done. And let me tell you people, I was here in 2003 when the Constituent Assembly statute was being debated in the NRC. Was it NRC? It was not Parliament, because Museveni was still the chairperson. It was the NRC. So the Constituent Assembly spent more than 9 days, actually spent the longest time on the chapter on fair trial, because there was so much to be said. For example, there was the Public Order and Security Act. You people, you didn't know about it. The Public Order and Security Act gave the power to the Minister of Internal Affairs to think, if he thinks that so and so has committed an offense, that person can be detained. The Public Order and Security Act was eventually repealed by this very government, because they said it was a very unfair law, because it meant that people are being taken to court without trial. Then lastly, I've told you of the case of Hadija Namgerwa. Salim Muhammad was charged with being found in possession of a star pistol. Now the star pistol eventually the Supreme Court said that if you are found in a possession with a weapon ordinarily the monopoly of the UPDF, then you are supposed to be tried there. So when we were leaving court, I saw one of the judges, I can't mention his name now. One of the judges had his pistol from his pocket fall down. And to me, it looked like a star pistol, but anyway, he was a judge. I don't know if he had that pistol even in court, but you can see the unfairness of some of these things. I have a lot to say, but I think I've said enough. Thank you very much, Radko Nyuba.